Hi, I'm attorney Kelly Longtin, and welcome to our YouTube page of Kelly Longtin Law. And today I want to talk to you about how your business documents may be relevant to your estate plan. Now, studies consistently find about 25 to 35% of Americans have an estate plan, a shockingly low rate when you consider that in the absence of a plan, the state, not you or your family, decides what happens to your assets, including your business interests. The overall business succession planning rate is higher, with about 2/3 of business owners having a succession plan in place, according to a recent Edward Jones survey. The planning rate is lower, however, for family businesses. PwC's Family Business Survey found that fewer than 1/3 of family businesses have a formal succession plan. Now, for most business owners, their company is the most valuable thing that they own. Yet more than 1/3 of all business owners do not have a legally binding plan in place, addressing their business ownership interests and how they should be transferred. Many have not taken the most basic succession planning steps, such as valuing their business. Those who have incorporated their business into their estate plan often have outdated plans or gaps within their plan, which could lead to unintended consequences. Now, business owners should have an up-to-date estate plan that aligns not only with their succession plan, but also with the business's governing documents. Now, company rules about transferring business ownerships are found within documents, such as a limited liability company operating agreement, a partnership agreement, corporate bylaws, a shareholder agreement, or a buy-sell agreement. To help a client properly plan for the future transfer ownership of their business, an estate planning attorney must review all of these documents. Now, some entrepreneurs make a conscious effort to silo their business life and their family life, while others have family businesses that make the two nearly inseparable. In both cases, business succession planning and estate planning, although technically separate processes, often overlap and should work together. A business succession plan provides a blueprint addressing what will happen when you leave the business, whether by selling it, retiring, becoming unable to manage it due to age or health, or transferring it to successors upon your death or during your life. An estate plan defines what happens to everything that you own, including tangible assets like real estate and personal property, as well as financial assets like investment accounts and business interest, when you are no longer able to manage your affairs or when you pass away. Now, the ideal time to decide what to do with your business is while you still can. The first step is to establish your goals for the business, whether it's transitioning the business interest to family members, selling it to employees or outside investors, or transferring it to co-owners. Now, once you have defined a plan for the ideal outcome for your business, you can begin the conversation about business continuity, tax mitigation, and other core estate planning considerations important for entrepreneurs. Now, unlike a home, retirement account, or other personal asset, you may not be free to do whatever you want with your business ownership interest if the business has more than one owner. Partnership corporations and LLCs have governing documents with information concerning an owner's contribution, ownership percentage, and transfer provisions. When preparing an estate plan with your attorney, it is crucial that the attorney has access to review your company's governing documents that detail your stake in the company and whether and how you can transfer your ownership. The attorney needs to examine your business documents to determine exactly what you own and are entitled to from the business. Now, if it's a corporation, do you own shares of the company stock? If it's an LLC or a partnership, what is your membership or partnership interest? How much did you invest in the company? And what is your distribution amount? You also want to know is, do your membership or partnership interest and distribution shares correspond with the size of your investment, or are they based on a different calculation? The attorney also needs to know about any contractual provisions that restrict the owner's ability to sell or otherwise transfer all or any part of their interest. Now, there may be a provision requiring you to obtain consent from other owners before selling or transferring your interest. Now, an agreement could also limit to whom owners can transfer their interest. Permitted transfers may be limited to family members or trust. Sometimes these types of transfers may be allowable, but they still require prior approval. If so, does the approval require a majority vote or a unanimous vote of the other owners? An estate plan and business succession plan that do not factor in such provisions are almost assured to fall short of their objectives. For example, as part of a business succession plan, an LLC owner might intend to leave their share of a business to a spouse or child through a trust that is established in their estate plan. However, if the LLC governing document restricts the transfer, it could be disallowed or voted down. Contractual obligations typically take precedence over any conflicting estate planning documents that a business owner may have signed. There could also be a provision in the operating agreement stating that an owner has the right to pass their business interests to family members, but the family members will not have management or decision-making authority. Such a provision may allow the family to receive income from the LLC, but not permit them to actually manage the business. Now, not knowing how much a business is worth and the corresponding value of an owner's interest in the company could lead to unexpected estate tax issues when gifting or transferring shares to a family member. So the entrepreneurial journey has many steps, twists, and turns. Part of the journey often includes stepping away from your business at some point. Long before you do that, however, you need to have a plan that reflects and considers the current state of the business, your finances, and your long-term goals. Aligning your estate plan with your business succession plan and business governing documents can help ensure a smooth ownership transition that protects your business interest, preserves business value, and successfully positions you and your family for what comes next. Make sure your plans are up to date for the eventual transfer of your business. You want to talk to your qualified estate planning attorney to either start or update your plan today to make sure all of your business interests align appropriately with your estate plan. I want to thank you for watching. Please like and subscribe our page below. I'm attorney Kelly Longtin from Kelly Longtin Law.